Kevin has a rather colourful background. He not only is he a senior lecturer, but he has also, in a practical sense, been involved in a number of international news events, I should say, including the trial of Saddam Hussein, and as an advisor to Gravatt Campus's legal associates, of which I'm sure we might hear something later on. But for the moment, today I'd like to invite Kevin to take it away to discuss today's topic, which is can the US prosecute WikiLeaks for espionage, and should it? Thanks very much.
Thank you, Tim. Nice to be here. It's my first time at Griffith. Thank you all for coming, particularly those of you who don't know me and are already obligated to be at my talk. And thanks to you, Ed, since you're truly the outsider who came to hear me. So I'm going to try to speak for 35 minutes and give us plenty of time for discussion, which hopefully there will be some afterward. Okay, so you see the title of the talk. Just a little bit of background. On November 28th, 2010, WikiLeaks revealed that it had obtained about 250,000 classified State Department cables. All of those cables are in fact classified, either at the confidential or secret level. There are in fact no, quote, top secret level documents in that set of files. And I think it's just kind of funny that in fact the government actually uses expressions like top secret. I thought that was just spy movies, but not. It's widely assumed, of course, that WikiLeaks obtained these State Department cables from Bradley Manning, a private in the US Army who has a background in intelligence analysis. And in terms of the release of the cables, at least initially, the bulk of the cables were released by media organizations in partnership with WikiLeaks, not by WikiLeaks itself. The list of newspapers with which WikiLeaks partnered include kind of most obviously the New York Times, The Guardian, Der Spiegel, Le Monde, etc. That was initially. A few weeks ago, as you might know, a reporter for The Guardian published a book. And in his book, he published the encryption key that would allow anyone with access to the BitTorrents that contain all of the cables to look at all 250,000 of them whenever they chose. WikiLeaks was concerned that the confidential informants that were named in the cables might not know that, say, security services all over the world could find their names in the unredacted cables, and so WikiLeaks made a conscious decision that it would be better to release all 250,000 publicly than risk a confidential informant not knowing that their identity was essentially public. Now, in terms of my talk, for the past few months, a federal grand jury has been meeting in a courtroom in Virginia to determine whether to actually bring some kind of criminal charges against Julian Assange. Well, why do we, or how do we know that? We know that because of a subpoena that was delivered to one of Bradley Manning's associates in Boston. That subpoena indicates that prosecutors are investigating, quote, possible violations of federal criminal law involving, but not necessarily limited to, conspiracy to communicate or transmit national defense information in violation of the Espionage Act. So, given that, in this talk I want to consider the possibility of espionage charges against Julian Assange, and more particularly, I want to try to answer two obviously interrelated questions. First, can Assange be prosecuted for espionage? And second, should Assange be prosecuted for espionage if he can? I think it will not take you very long to figure out that my answer to the first question is yes, and the second question is no, but I will walk you through the analysis. Before I do that, however, let me just give you a very, very capsule synopsis of background to the Espionage Act. I don't think most Americans know the background of the Espionage Act, so unless you work in this area, I can't imagine why an Australian would. For 120 years, from the expiration of the Post-Independence Sedition Act of 1798 until the beginning of World War I, the US actually had no federal legislation that criminalized seditious or treasonous speech. As the United States came closer and closer to entering World War I, however, President Woodrow Wilson's administration started to become increasingly nervous that, as the president himself put it, the United States, quote, had no laws adequate to deal with the insidious methods of internal hostile activities. That concern led Congress to enact the Espionage Act in 1917. It is important to note, though, that the Congress did not pass the Espionage Act without bitter debate and bitter division among the various parties and the senators and representatives. In fact, more progressive members of Congress actually managed to soften the act in a number of important ways during the negotiations, most notably deleting a provision that would have given the president the power to prevent the publication of any information that he believed would be threatening to America's national security if in fact it was released. So, if you look at the text of the Espionage Act as originally passed, it's actually relatively narrow in what it covered. Unfortunately, as is so often the case, the actual application of the Espionage Act was anything but narrow. As John Lord O'Brien, I probably shouldn't cover that up, as John Lord O'Brien, the head of the Department of Justice's War Emergency Division, acknowledged shortly after the end of the First World War, the department was under enormous pressure from the Wilson administration throughout World War I to, as he put it, quote, indiscriminately prosecute dissenters and engage in, quote, wholesale repression of public opinion. And that was the head of the War Emergency Division admitting that. In fact, the Department of Justice invoked the Espionage Act of 1917 to prosecute more than 2,000 dissenters during the war for allegedly disloyal or seditious speech. And let me just mention what I think is probably only one of the many egregious examples of how this Espionage Act was used. So, a woman, Rose Pastor Stokes, was prosecuted for saying, quote, I am for the people and the government is for the profiteers, during an anti-war speech to the Women's Dining Club of Kansas City. Now, there were no soldiers in the audience. In fact, there were no men in the audience, but the government nevertheless argued that she had violated the Espionage Act because American soldiers could succeed, quote, only so far as they are supported and maintained by the folks at home, and Stokes' statement the government believed would, quote, chill enthusiasm, extinguish confidence, and retard cooperation of mothers, sisters, and sweethearts. In the war effort, Stokes was convicted and sentenced to 10 years in prison. And again, if I had more time, I could multiply these examples considerably. So, that's a little bit of background to the Espionage Act. Let me turn to the first question. Can the United States prosecute WikiLeaks and Julian Assange for espionage? First thing that needs to be said is that no media organization has ever been prosecuted for espionage, for publishing classified information that had been stolen by a government employee. Indeed, other than these kind of outlying early prosecutions, the Espionage Act has only been invoked once against someone other than the government employee who actually stole the classified information. That case is United States versus Rosen, better known as the AIPAC case, in which two lobbyists for the American Israel Public Affairs Committee orally received classified information from a Department of Defense official. Those two lobbyists then passed that information along to the Israeli government and to a journalist, and they were charged with violations of the Espionage Act. Those charges didn't really go anywhere. The US government ultimately dismissed those charges, kind of ironically enough, because the government didn't want to turn over the classified information to the lobbyists that the lobbyists would have needed to mount a defense to the espionage charges. So that's the only time it's ever been invoked, much less successfully invoked, against someone other than the government employee who stole the classified information. Now, a couple of months ago, Baruch Weiss, who was a lawyer who defended one of the AIPAC defendants, he published an editorial in the Washington Post entitled, quote, prosecuting WikiLeaks, good luck. I wish I could stand before you and share his confidence, but I don't. The fact that the Espionage Act has not been used against a media organization certainly doesn't mean that it can't. And on the contrary, I think if the United States government ever gets its hands on Assange, and we can talk about some of the extradition issues if you're interested in them, I think the US government would have very, very little difficulty convicting Assange of espionage. So, let's start with the good news in this regard. The government would like to charge Assange and WikiLeaks with conspiring to commit espionage or soliciting espionage. If those were the charges that were brought, it could then convict Assange, oversimplifying a little bit, without proving that WikiLeaks itself ever violated the Espionage Act. It would only have to prove that Bradley Manning, violated the Espionage Act, and in some way, WikiLeaks conspired or solicited him to do so. Now, fortunately, the government has essentially conceded that they can't make the case for conspiracy or for solicitation. They can't show that WikiLeaks in any way worked with or helped Bradley Manning to obtain these cables. It seems pretty clear, again, even by the US government's own admission, that he was a classic whistleblower. He stole the documents because he believed that they needed to see the light of day, and he took advantage of the existence of WikiLeaks of his own accord to turn the information over to the organization. So, it seems clear that the government would have to prove that WikiLeaks itself violated the Espionage Act. Now, there are a number of provisions that WikiLeaks and Assange arguably violated. I want to mention just 3 of them during this talk. And I want to examine only those 3 because I think they are the best ones to illustrate, first, just how dangerous the Espionage Act really is, and second, to indicate just how radically the US government is willing to interpret the Espionage Act in order to convict someone like WikiLeaks or perhaps WikiLeaks itself. So, the first provision I want to discuss is 18 U.S.C. section 793C. This is, of course, from the US Federal Code. It is perhaps the most dangerous provision of all because it criminalizes any act of receiving national defense information that the defendant knew had been illegally obtained. And there are 3 requirements here that are particularly important. First, the document in question had to be connected with national defense. Now, connected with national defense is obviously a somewhat vague concept, and in fact, one government employee prosecuted for espionage, one who actually stole the information himself, argued that it was so vague that this element of the crime violated the US Constitution's guarantee of due process. The United States Court of Appeals for the Fourth Circuit rejected that argument in a case called United States versus Morrison, and it held that information, quote, connected to national defense was limited to information that satisfied 2 requirements. First, that information had to be, quote, potentially damaging to the United States, or useful to an enemy of the United States, functionally the same thing. And second, it had to have been closely held by the government such that it was, quote, not available to the general public. In other words, it had to be classified. That is a very low standard for connected with national defense, particularly because, at least in theory, you can only classify a document whose release would in fact jeopardize America's national security if it was released. Now, obviously there's huge problems with the overclassification of information, but the statutory standard is you can only classify information that would harm national security if it was released. So, in effect, this requirement reduces to, was it classified? If the document in question was classified, it will be, by definition, connected with the national defense. That's the first element. The second important element, the document must have been obtained by any person contrary to the provisions of this chapter. In the context of WikiLeaks, this, of course, refers to Bradley Manning's theft of the State Department cables. As long as that theft itself violated the Espionage Act, and trust me, it did, the requirement would be unproblematic in a prosecution of Julian Assange. Third element, knowing or having reason to believe. This, of course, is the mens rea requirement. Under this provision of the Espionage Act, the US government would have to prove only that Assange knew or had, quote, reason to believe that Bradley Manning had violated the Espionage Act when he took the State Department cables. This is also a very low standard. As long as Assange should have known that Manning violated the Espionage Act by taking the cables, and that, of course, is a simple negligence standard, the element is satisfied. And that's really it for this first provision. The bottom line, Assange would be in very serious trouble under this provision.